Universal with the pencil at one point in time, so that's all right.
Good morning, everyone. Welcome to House Judiciary. Debbie, will you call the roll?
Representative Craigo.
Here.
Representative Chestick.
Here.
Representative Haroldson.
Here.
Representative Jennings. Representative Nemec.
Here.
Representative Oakley.
Excuse, she's gonna be a little late.
Representative Provenza.
Here.
Representative Rodriguez Williams.
Here.
And Chairman Washut.
Here. All right, first up, we have Senate File 181. Senator Schuler is here. Why don't you walk us through the bill?
Thank you so much, Chairman and members of the committee. Sounds like I've got a little echo here. I'll back up a little bit. I mentioned to a couple of you, I started out with a bad day already. I got here and I realized that I have brown pants on and a black jacket. So if I get thrown off my A game, that's what it is. Representative Jennings said you didn't notice, but it's bothering me. But anyway, we'll move on. This bill is more important, correct? Yeah, should I try a different one? Yeah, let's turn. Is that better? A little bit better? Okay. This morning, I bring you Senate File 181, drug-induced homicide. The idea for this bill actually came from our county attorney in my county, and some of the folks that in the law enforcement area, DCI and so on. Unfortunately, because we're on I-80 and we're right across the border from the state west of us, we seem to be right on the pipeline where a lot of drugs come in to our community and get dispersed from there, and seeing more and more issues with drug deaths. And so we decided to go ahead and take a look at the drug-induced homicide statutes and see if there was some way we could kind of up the ante a little bit for those people that are dealing the drugs. That's really what this bill is really focused on, are the drug dealers. And so really, we're just amending 62108. 62108 actually already has an amendment in there for if someone violates 35-71031 and they deliver a controlled substance to a minor and that minor dies. This basically just adds fentanyl, heroin, and methamphetamine. We decided to focus on just those three drugs because those seem to be the three drugs, we call them the big three, that cause the most issue in our area. And so basically what the amendment is if someone unlawfully delivers one of those three drugs to another person, and that person dies as a result of the injection, inhalation, ingestion, or administration by any other means of any amount of the fentanyl, heroin, or methamphetamine, they would be hopefully convicted of a drug-induced homicide. In doing my research, I found that really we have more felonies with drug crimes than anything else, and that kind of surprised me. You would think it would be violent crimes and a variety of other things, but it's an issue in our area, and I'm fairly certain anybody on I-80 probably has the same issue as well as I-25. But we just seem to be in a situation where we're seeing a lot of it. So we did have an amendment added on our side. I don't know if you want me to talk about that a little bit, but and this is it'd be on page 1, line 8, and page 1, line 9. We created a new subsection C. Excuse me, the amendment's on page 2 after line 17. And what the situation there was that one of the folks on our committee felt like, what if it's not the drug dealer that gets nailed? What if it's someone that just brings a load of fentanyl to a party, and then all of a sudden someone is in bad shape? So basically what that says is that it shall be a mitigating circumstance at sentencing for any person convicted under this section if the person, little I, contacted law enforcement or emergency medical services to report the need for medical assistance for the victim as a result of a drug-related overdose, or two, little I, provided first aid or other medical assistance to the victim if the victim experienced a drug-related overdose. And that would all be done in the courts. So, and I'm not a lawyer, so I'm not sure how they look at mitigating circumstances, but they wanted to mainly just take a look at the middleman, whereas this bill, I think we really focused on the dealers criminals, the people that are bringing it in. And that's why we looked at the drug induced homicide amendment to start with. It talks about delivery of these drugs. So I think that's pretty much the bill. It's a pretty short bill. I know it has a lot of complex effects that could happen one way or the other. And again, not being a lawyer, I have no idea how law enforcement would handle how they would get back. I'm sure that there's probably going to be some issues trying to get to the dealer, trying to figure out who brought the drugs in. And so I know there's middlemen in between, but we're really trying to get at the dealers. And whether or not it'll be a deterrent, I don't know. We hope it will be, because obviously there's, before, I had people say, well, if someone's just convicted of criminal negligence, rather than this drug-induced homicide amendment, it could be a misdemeanor with prison. They could be fined $2,000 and maybe a year in jail. So really what we're doing actually is putting the hammer down and saying, no, this is drug-induced homicide. It's going to cost you some years off your life if you're delivering to someone in our state or our communities and they die as a result. And again, we're talking the adult, the minor's already in the drug-induced homicide statute. So with that, I think that pretty much covers everything. I did have just one more thing, if it's all right, if you'd indulge me. I had a girl from a young lady from Rock Springs who sent me a letter right before I brought this up in the Senate side and talked about the problem of fentanyl. She originally was from Evanston. I don't recognize her name, but she's moved to Rock Springs. And she said that she got into fentanyl and obviously became addicted. And she finally got help and wants to be a therapist and help out with substance abuse problems and help people with problems. So it is getting into our high schools as well as, older people. And so I think it is a problem no matter where we go. So that's the bill, and I'm happy to answer any questions I can.
Questions for Senator Schuler? Representative Provenza?
Thank you, Mr. Chairman. Thank you, Senator. It looks to me like what this is doing, in addition to adding these new substances, is broadly expanding it from where it was minors before to anyone who overdoses. Is that your intention?
Senator Schuler?
Chairman, Mr. Chairman and Representative Provenza, yes. The only difference between this amendment and the one with the minor is the minor actually, if you look at their section about the minors, is they actually include other drugs. They include cocaine and some other drugs, opiates. This just focuses on just those three drugs, the meth, the fentanyl, and the heroin.
Follow up?
And Senator, I don't see, so oftentimes we'll see in our criminal statutes knowingly or some form of intent, and I don't see any in here. I can understand that line of thinking for minors, especially if you're somebody who's responsible for that minor, but it doesn't exist in this Romanet 2, which then broadens it to all people.
Senator?
Thank you, Mr. Chairman. Representative Provenza, you're correct. We did talk about that, knowingly, but to me, again, I think if you're a drug dealer, you know what's going to happen. You're going to make some money, but you probably don't think about whether or not you'll kill someone as a result. But we did talk about that, and we decided not to add that language. But I would be open to that if that's something you so desire.
Further questions for Senator? Hearing none. Do you have other witnesses who are with you, or do
I think we had our county attorney, I believe, was
Yes,
going to try to testify
Loretta.
this morning.
Howison?
Yeah.
You bring Loretta Howison in, please. Did I pronounce that right?
Good morning. I have to apologize. I'm in my son's room because of the fact we have a little teeny tiny bit of snow over here on this side of the state. How are you this morning?
We're well. Please state your name and your office and tell us what you want us to know about Center File 181.
So my name is Loretta Howison Callis, and I am the Uintah County Attorney. I took office in 2015. And I appreciate Senator Schuler championing this bill. As she is well aware, because of some concerns and other things, she's worked with many lawmakers even before presenting this in its current fashion, and I do truly appreciate that. I want you all to know that just as recently as last Saturday, we had a 17-year-old in our hospital who had overdosed on fentanyl. We've had 3 deaths in Uintah County in the last year between heroin, fentanyl, and methamphetamine. One good example that I would like to make sure your panel is aware of is an individual who had actually been successfully processed through our drug court. He had been clean and sober for over a year, and unfortunately he relapsed. He thought he was taking heroin, and in fact, he had fentanyl-laced heroin, and he died. We were not able to even engage in a criminally negligent homicide, which is a misdemeanor, as Senator Schuler has engaged, because there is an extensive amount of investigation that has to occur in order to link these individuals to the dealer, which is the intention. And so since the family determined that they did not want to release, for example, his cell phone to DCI, that investigation did not occur. We had another circumstance, however, where we did in fact prosecute a criminally negligent homicide in the last year related to the death of a 22-year-old woman who died after a dealer had came up and partied with her and delivered a substantial amount of drugs to various people, and she died of a methamphetamine overdose. And so those are just 2 examples. I probably could provide you more. I did hear Representative Provenza ask about the mens rea, the criminal intent. And I would note that the mens rea is actually already in your statute. Certainly, if you would wish to put that in there, whether it's knowingly, recklessly, or intentionally, there is, and Representative Crago certainly knows this as well as I do, there's a level of mens rea that's in the delivery. That's already provided through the language. We have to prove not only the link between the controlled substance and the death, so the causation, but we also have to prove the delivery, which would then fall into Title 35. I just significantly, I guess, just to finish off as far as anything before asking for questions, while I understand that the statute is there and is provided for children, as Senator Schuler said, and we should cherish and protect our children for all things, any controlled substance, quite frankly, if it can be proven. And that is, as I just noted, a fairly extensive multiple layer level of proof in order to facilitate that demonstration. When you have a family member who is lost, and they are lost because of an act that is done for profit in most cases, and the amount of drugs we have coming up from Salt Lake, and that's just the panel that's coming through from Mexico, quite frankly, then it is certainly something that avenue should be optioned for them. An intentional death, which these drug transactions are intentional. They know what they're doing. They're transferring them to gain money, whether it's for their own substance use or for cash. And there are 2 different selections, then that is important. In addition to that, the prosecutors are not necessarily always going to use this. It is just yet another option if it is demonstrated to be needed. And finally, I would also note, if you guys are amenable to any modifications, one thing that we do have concerns about for all of our controlled substances statutes, even the one that's going through for child endangerment, is that in listing specific drugs such as fentanyl, heroin, and methamphetamine, it may be prudent to include isomers and substrates and derivatives, because what is happening on the street, I'm sure you guys are aware of this. I know you've been having some educational training. but heroin and cocaine and methamphetamine are expensive. And so what drug dealers are doing, because the fentanyl is so cheap, it's coming in from these manufacturers in China and Mexico and over our border, is that they are cutting the methamphetamine and the heroin and the cocaine with the fentanyl, because it'll give a similar high. So the user feels the same effect or a similar effect, but it is so many times more deadly. And so it is something that is of note that if you don't include those isomers, derivatives, and substrates, that may not be something unless we can demonstrate a significant amount of the fentanyl. So with that, if you have any questions, I'm happy to answer.
Questions for the county attorney? Representative Provenza.
Thank you, Mr. Chairman. It's a little early. Thank you for testifying today and for being here. I have a question about the delivery statute. So that 35-7-1031, paragraph A seems, I mean, to me, it seems pretty broad. So I'm trying to understand how this is just getting kingpins, or this is just getting drug dealers who are maybe knowingly doing this. Oftentimes, I think we see that folks who are delivering are family members or friends of these folks and not necessarily drug dealers. And so I'm hoping maybe you could explain to me how this isn't going to get those instances, and this is only going to get quote unquote drug dealers and kingpins.
With due respect, Representative Provenza, I have about 182 active felony cases that I am handling right now. That's fairly average. We have about 120 new felonies a year in Uintah County, more or less by 20. And 30% of them are probably controlled substances violations. We do get a lot of interdiction cases, and the distinction for that, of course, those are the cases where they're pulling drugs off of the interstate. But the vast majority of our local cases are delivery cases through our local division of criminal investigation. And I am sitting here trying to think of a single one that involves a delivery between friends or family members. These are people that are delivering controlled substances in a transaction where they are gaining money. There are times, certainly, when there are small quantities, and we certainly take that into account. But at least here in Uintah County, we are oftentimes dealing with 8 balls and higher for deliveries, which is 1/8 of an ounce. And so we aren't having deliveries, at least that we're prosecuting, that have to do with transactions at a party or transactions with friends, because those are difficult to prove. You have to be able to demonstrate who actually went from one to the other. And so I can't imagine a way that we would be, somebody hanging out with their friends, passing a bong around or something to that effect. That's not what is actually in our courtrooms.
Thank you. Further questions? Thank you. We appreciate you. You might stay close. And sometimes questions pop back up later in the testimony.
Absolutely.
Anyone wishing to testify on 181? Ms. King? Good morning.
Good morning.
Oh,
Thank you, Mr. Chairman and members of the committee. I'm not here representing any organization today. It's just me and my own sort of interest in these matters. And
please state your name.
Sabrina King. Thank you, Mr. Chairman. I just wanted to provide a little bit more context and a little bit more background, particularly on the mitigating factor in sentencing. As I did work with the bringer on of the bill on this, and I think one thing to understand, and I think many members of this committee may be aware of this, is that Wyoming does not have any kind of comprehensive Good Samaritan statutes. So we have one provision that I think we passed in 2018 about the delivery of naloxone. So if you are delivering naloxone, that sort of very specific instance, you are protected from liability. But in a broad way, as states across the country have been dealing with the drug crisis, really since 2016, states have sort of stepped in and looked at Good Samaritan provisions. Wyoming hasn't really done that. We haven't kind of taken that broad of a view. So I think this bill is interesting in that it is going into, going into the drug-induced homicide statute and I think pretty broadly expanding it as was discussed before. But the reality is with drug-induced homicide, I think there are two things to keep in mind. The first of which is the vast majority of drug-induced homicides are witnessed, and they are usually witnessed by the person who provided the drugs. And so I think, for other Good Samaritan provisions, the intent of those provisions is to help people feel more secure and safe in calling emergency services, because that is the point. So the faster emergency services can get there, the more likely the person's life is to be saved. And there is some evidence, even in the limited time that we've had, that there are ways to do Good Samaritan laws that will actually encourage people to call emergency services. The other piece of the Good Samaritan laws, and I think what is put into this bill, is a mitigating factor in sentencing, because the reality is, two things. We had the discussion about delivery, but if you actually look at the definition of delivering, it does mean the actual constructive or attempted transfer from one person to another of a controlled substance, whether or not there's an agency relationship. So the reality is, even if the intent of this, and even if the vast majority of what our prosecutors are looking at right now is, those kingpins, those folks who are, really delivering the homicides, this statute does apply to one person who has handed someone else drugs. In those instances, I think in particular, if that person, having no intent whatsoever of having that person lose their life because of a drug overdose, does everything in their power to save that person's life, it should be a mitigating factor in sentencing. And that, I think, is really what we're trying to get at with this. So it's in no way, shape, or form, broad strokes look at what we could do in our Good Samaritan laws. And I think it would be interesting to look at those over the next year. But of all of the states that have kind of grappled with this, 24 other states have some sort of mitigating factor in sentencing. So it's not at all unique. So just for broader context, and I think for some of the broader understanding of where Wyoming sits, and I think the importance of, in particular, having that provision in this bill. So happy to answer any questions.
Questions for Mr. King? I have one on the Good Samaritan. Then the language now provides for either calling emergency services or providing first aid. And I think of a circumstance where there are two people present, the one who's in distress and the dealer who provided the drugs. How do we know the extent of first aid that was provided? Right? If they don't call 911 or call for help, they just do the first aid. How does that work in court for the mitigating factor of, I tried to do CPR, or, I lifted his ankles off the floor to give him some blood flow, or, what exactly constitutes sufficient first aid? And should it be an and rather than an or could we do away with the first aid provision and simply say, if somebody goes down, you got to call 911? Ms. King?
Mr. Chairman, I appreciate that question. And I think, for that provision, there would obviously have to be some evidence of having provided first aid in order for the court to be able to use that. And so whatever that evidence might be, either evidence of CPR, whatever the defense in the court might be able to say, like, we can prove that there was some first aid that was given. So I think it would certainly rise above beyond, far beyond the person just saying, well, I gave them first aid. As I said, states kind of handle the mitigating factors differently. I think I will say from my perspective, the most important piece is that there is some sort of mitigating factor in sentencing, and whether that is that they've called emergency services, there may be a level of, like, a standard of proof that maybe need to be put into sort of that second provision. But honestly, I think the courts would handle that. And frankly, I think if there wasn't sufficient evidence that first aid was rendered, then it wouldn't be considered a mitigating factor.
Any other? Representative Provenza.
Thank you, Mr. Chairman. Ms. King, so I think there are 3 states that have complete immunity in terms of at least the homicide portion. If they call 911 I mean, what are your thoughts on that? Is this gonna do what we need it to? What does this look like in a courtroom? Just kind of walk me through, maybe if you were aware of those statutes in other states and if they work, or why we came to this.
Ms.
Yeah.
Green?
Mr. Chairman, Representative Provenza, as I said, and especially when it comes to drug-induced homicide specifically, states really do handle them quite differently. There's a handful of states that have sort of mitigating factors in sentencing. There are some that have immunity for prosecution. As you said, it's relatively rare. There are 4 states that have, if you've called emergency services, it's actually an affirmative defense. And so I think in the conversations about this provision, it was, well, what is going to make the most sense in Wyoming, and what is going to be the piece that fits, I think, the best in this bill without taking sort of a more comprehensive look at Good Samaritan statutes. And like I said, there's sort of two elements to the Good Samaritan provisions, one of which is mitigation of damage, right? So getting emergency services called. For the mitigating factors, that isn't necessarily what we're looking at. We're looking more at sort of, call it maybe, if you will, a philosophical view of how the criminal justice system should handle these issues. And if you have not intended to end someone's life and you try to save them, then that should be a mitigating factor. It is where there's the most evidence for Good Samaritan laws actually increasing the number of 911 calls is if there are provisions around not being arrested for, say, having drug paraphernalia or, whatever else that might be. And so Good Samaritan laws are actually relatively complex. And again, I think it would be a very interesting thing to have a conversation about over the interim, because this is a gap in our laws that we could fill relatively easily. But I think in this specific provision, there isn't really, I think, room, neither in this bill or in kind of the context of the conversation to do that broader look. But I think just in the context of drug-induced homicide specifically, the mitigating factor in sentencing was, I think, what fit the best and what made the most sense in terms of Wyoming statutes.
Thank you. No further questions. Appreciate you being here this morning. I think we have Mr. Greg Hunter. Bring him on, please. Good morning, Mr. Hunter. Please state your name for the record and where you're calling from, and tell us what you'd like us to hear on Senate File 181. Please direct all your comments through the chairman. Thank you.
Good morning, Mr. Chairman, members of the committee. My name is Greg Hunter, and I'm speaking to you from the living room in Laramie, Wyoming. When I first wanted to testify on this bill, I didn't think it would be as hard as it is going to be. My best friend and brother-in-law died of a heroin overdose on April 24th, 1999. And some of the issues that you've been discussing today, the arrival of the coroner, the discussion about whether the people involved should be prosecuted. Did they try to render during this overdose? Did these friends, drug dealers, however we want to put it, render aid? And it is, we do find out after a while that there are a lot of things that occurred, but we don't really know whether any aid was rendered. These things happened almost 24 years ago, and we are still trying to wage a drug war we're losing. And we are, when I listen to this testimony, we are creating felons by the boatload who cannot work in our society. We are not really mitigating the problem at all. We are creating a much bigger problem. I was with my brother-in-law when Roy Boots picked him up. I had known Roy was not a good person, but I helped my brother-in-law a lot. I loved him. We were breeding horses, and I'm sure Mr. Boots was part of the problem. But we did not, and everybody chose not to prosecute because that was not the solution. Roy Boots ended up dying of a heroin overdose later on in life, probably 8 years later. So 24 years have gone by. I have sent, the judiciary a recommended interim discussion that would actually solve a lot of problems. I realize that we want to jail everybody that participates in these activities, but that is really the wrong solution. So I would really ask that you take a different tact, because none of these solutions that you're working on are going to solve any problems. They are just going to create more and more felons, and we are really not addressing the issue. So I stand for any questions. It has been very hard to lose somebody and recognize that, they're never going to be here, and corporations in the interim in the 24 years have hooked more and more people, and we are still not addressing the problem correctly. I thank you for your look at this, and I'll stand for any testimony or questions.
Thank you, Mr. Hunter, for your heartfelt testimony. Representative Chestic.
Thank you, Mr. Chairman, and thank you, Greg, for your, I know that must have been very difficult to provide that testimony, and I'm very sorry for your loss. So the solution, could you tell me what the solution is if it's not criminal enforcement? What solution are you suggesting we study in the interim?
Well, I sent a requested interim testimony. Chairman Washington did respond to it, was not going to support it. If we really look at these things, and if you look at history, Wyoming history and everything, Prohibition caused the largest crime wave in American history. We banned alcohol. And at the very same time, we banned naturally occurring plants. You cannot ban naturally occurring plants. And what happened, Prohibition proved we caused the largest crime wave in American history. What banning naturally occurring plants did was cause the largest international crime wave in world history, but we really don't look at it. So my contention is—
Mr. Hunter, we have 3 other bills we have to hear this morning. I don't want to get into a whole dialogue on cannabis or other products, but
no, I was
summarize very quickly for Representative Chestic's question.
Okay. I was just on my last, excuse me, Chairman Washington, Representative Chestic. If we had not banned naturally occurring plants, there would not be fentanyl and methamphetamine in society today. So we've created this problem, and these bills are not going to solve them. Thank you very much for the question, Mr. Chestic. I'll stand for any more.
Any further questions for Mr. Hunter? Thank you. Seeing none. Thank you, Mr. Hunter, again. Anyone else in the room wishing to testify on 181? Seeing none, we'll close. Is there anybody else on Zoom? We'll close public testimony. Committee, what's your pleasure? Moved by Carlson, second by Oakley. Discussion, amendments. Representative Provenza.
Thank you, Mr. Chairman. I would move. Oh, that's already in there. Great. The mitigating factors are in. I support the mitigating factors, Mr. Chairman. I guess that's all I need to say about my proposed amendment. Nothing burger.
You have an amendment? Okay, Representative Oakley. Either.
Thank you, Mr. Chair. And I know I wasn't here for the testimony, so I apologize about that. I was thinking about the mitigating factors, and I'm not a big fan, to be honest. We are looking at a deceased person with a cap of 20, first of all, but also that's what judges do every time they listen to sentencing. I mean, that's every single sentencing, even for misdemeanors, is an individual undertaking. There's no mass sentencings ever, and there certainly wouldn't be in a case like this. So victims' family will come forward. The defense attorney, every single one has a defense attorney. We'll talk about all these factors. And I'm just a little hesitant to be putting what the judge should and shouldn't do in black and white. It's not commonly, it's not something I see commonly. So those are my thoughts on the mitigating factors. And like I say, I know I didn't hear testimony, so I apologize about that.
Other comments on the bill? Representative Provenza?
Thank you, Mr. Chairman. You know, this statute, I think, is harder to prove than the delivery statutes that we already have, has the same sentencing. We can't do both of them. But I think it's harmful to have just to be convicted of drug-induced homicide with this also. Sorry, I'm jumbling words. I'm early, I guess. I don't know. My brain is broken at this point in the session, but I guess what I want to say is I can't support this bill. I think and what I know to be true is that there's ample evidence that says that what these laws do, where they say you could potentially be in a lot of trouble, is that the research is clear. It's often that folks don't call 911. You see a drop off in that. And despite having a spike in prosecutions for drug-induced homicide, you see an increase in overdose deaths directly after these laws have been instituted. That can be attributed to that specifically, not just the different availability or all the other factors. So we're looking at a jump of 7% to 20% in a single year for some states. So more people are dying because they now feel like they can't call 911. And despite what the prosecutor said in testimony, there's also ample evidence that suggests that we're not getting drug kingpins. We're not getting just dealers. We're getting a lot of folks that, dealt a small amount or whatever, but somebody died, and we're not getting the people manufacturing the drugs. They're not here. They're not in the state of Wyoming. Oftentimes the folks that are bringing these are drug mules. It's just far more complicated. And what this will do is end up in having more people who are unwilling to call 911, who are unwilling to seek help for folks, and takes us in the wrong direction, including putting more people in prison. So I'm against this bill. And I hope that the committee can also be against this bill.
Thank you. Representative Rodriguez Williams.
Thank you, Mr. Chairman. I would like to propose an amendment. I appreciate the comments of the testimony that we heard from the county attorney out of Uintah County, and definitely have concern over the way that they're cutting meth and heroin with fentanyl, and the need to include isomers, substrates, and derivatives into this bill. It sounds like this needs to be a little more expansive and perhaps be integrated into other statutes. But for today, I'd like to propose that suggestion. And I think perhaps maybe on page 2, between lines 14 and 15 would be the appropriate place, but I'd be open to discussion on that.
It's more of a conceptual amendment, or you want to actually insert those words? Representative Craigo.
Thank you, Mr. Chairman. And I guess it hasn't necessarily been seconded, so I don't know if I'll second it for purposes of discussion. I'm a little bit concerned about adding the language right in here, because if you go look at 35-7-1031, which is actually the underlying cause, I'm gonna say the underlying crime, we have to violate 35-7-1031 before this statute can come into place. And that language is not in 35-7-1031, which I think it actually needs to be. And that's why we were having a little sidebar back here. We were talking about that. I think it's probably something we should look at through the interim and getting some of that language put in there. But I'm afraid if we put it in here and it's not in the underlying one, we're just going to have confusion for our judges and our prosecutors trying to figure out, okay, well, does it have for the delivery? Does it have to not have isomers, etc.? but here it does. I'm just a little bit nervous about doing it here and not getting it in the underlying statute. That makes sense. So I'm probably against the amendment right now because I think we need to do it more holistically. Look at all of our statutes where that applies. I know we just passed a law here a couple weeks ago that probably needs its stuff back in there too. So.
Further discussion on the amendment. Representative Rodriguez Williams.
Mr. Chairman, thank you. I appreciate the conversation and I'll withdraw the amendment.
Representative Jennings.
I'd offer an amendment on page 3, 2 of them actually. I would like to change the shall to a may. And on the second amendment, if you want to deal with it first. Then I have a second. Line 2.
Line 2, changing the word shall to may.
Let it be permissive. I think it's already there and the courts already have it, but if we're going to leave this in, I'd rather turn it permissive.
There's a second on this. Second by Oakley. Discussion. All in favor, say aye.
Aye.
Opposed, nay. That amendment has carried. We'll change shall to may. Debbie, you got that? Okay, your second amendment, Representative Jennings.
Second amendment would be on page 3, line 10 and 11. I think the first aid is easier to qualify. The other medical assistance, words or other medical assistance be struck. I think that could be anything from here, lie down. And so I think it's too vague. So it would read provided first aid to the victim if the victim experienced a drug-related overdose.
There a second? Second by Nemec. Discussion. All in favor of the amendment, say aye. Opposed, no.
No.
The amendment has carried. To be clear, we're striking or other medical assistance on lines 10 and 11. Okay. Further amendments or discussion? Representative Shostak.
Thank you, Mr. Chairman, and I will be brief. I know that it's I don't know, fashionable or it's not more than that. It's there's a lot of conversation about how the drug problems we have is more of a public health issue than a criminal issue, and that the public health solution is the better solution. And I think that's what I was trying to find out from Mr. Hunter. And I agree that this is a public health issue, but I don't see public health and criminal law being either or. I think it could be a both and. I think they're two different tools to address the same problem. And therefore, I am going to be in favor of this bill. Although I do wish we had a stronger public health response and prevention. Drug prevention is probably the better solution. But at the end of the day, you still need to have the criminal sanction to make the drug prevention aspect more powerful. So I am in favor of this bill.
Thank you. No further discussion. Roll call on 181.
Representative Craigle,
Aye.
Representative Chestic,
Aye.
Representative Haroldson,
Aye.
Representative Jennings, Representative Nemec, Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Rodriguez Williams,
Aye.
and Chairman Washit.
Aye.
We have 8 ayes and 1 no.
Thank you. Representative Jennings, would you carry the bill on the floor? What's that? Anyone else? Representative Oakley, thank you. Senate File 99, Senator Barlow. Welcome back to House Judiciary. Walk us through the bill.
Good morning, committee. Thank you very much for the opportunity to present Senate File 99. I think Senate File 99, put it in context, you've already seen several bills. You'll have another bill this afternoon, or excuse me, this morning. I hope it's not this afternoon for your sake. That things we learned out of the COVID pandemic. You're gonna hear visitation rights. Senator McEwen's good bill. You've Representative Angelos brought a bill on visitation for clergy, et cetera. So we learned numerous things. One of the things that the legal community brought to me in my community, and who most represent people, citizens, and the institutions, was they couldn't actually get some of the legal services people wanted because facilities were closed. They were closed. So this bill spawns out of that. Mr. Chairman, on the Senate, on the bill is introduced with just to do with, it just had to do with during a pandemic or exigent circumstances. The Senate Standing Committee struck that and said, we should be able to do this business anytime. We are so used to doing business, or we have become more used to doing business with our technology. As you'll recall, 2 years ago, we passed a whole lot of laws completely remotely. And so this is just an extension of, I guess, what we're learning and what we can do. So, Mr. Chairman, this has to do with being testamenting, I guess, maybe that's not the right word, a will or witnessing a will. And I think the heart of the bill is on page 2, and it just allows, permissively allows someone, the witness is to observe the person via audio video communication. That is the entirety of the bill. This one service. Then the remainder of the bill is just giving this because we have these, basically forms, if you will, in statute that we say you have to a witness sign or electronically sign, which is also provided for in that section. So the rest of it is just conforming to how wills are actually done in statute. So, Mr. Chairman, that is the bill. The difference again is the Senate Standing Committee amendment, which was subsequently adopted, and the bill as it passed took out the exigent circumstances and public health emergencies, public health restrictions or exigent circumstances, and just applied it fully across the board. That's the bill, Mr. Chairman.
Questions for Senator? Seeing none? Are there any witnesses on 99? Anybody in the room wishing to testify on 99?
Very controversial.
Highly controversial bill here. Debbie, we call the roll on 99? No, Representative Harrelson.
Thank you, Mr. Chairman. So Senator, and just more of a statement before we vote. I had a number of individuals from my community that said we thought this was legal, but it wasn't. And so thank you for bringing this. This is kind of one of those, hey, why isn't this legal conversation? So thank you for bringing this forward.
Any amendments? Further discussion? Bill's moved. Second by Provenza. Question being called. Call the roll, please, Debbie.
Representative Cragel,
Aye.
Representative Chestick,
Aye.
Representative Harrelson,
Aye.
Representative Jennings, Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Aye.
and Chairman Washut.
Aye. And who would like to carry this bill on the floor? Senator, do you have a preference? Anybody co-sponsor anybody?
Mr. Chairman, after the last bill, I guess maybe my co-sponsors don't want to carry it. But certainly Representative Chestick said if he's interested.
Representative Chestick, thank you.
Thank you very much, committee. Have a great day. You've got a couple more good Senate files. I hope you'll give them consideration.
Senate File 108. Are we still on? We fall off the bridge here. We're still up. Okay, Senator Nethercott.
Thank you,
Please
Mr. Chairman.
introduce your bill.
Good to be back with you. In House Judiciary Committee, you have Senate File 108, Court Reporter Fees, District Court Discretion. Good senators, good representatives, this bill was brought to me by the court reporters of our state, of which we all have in our jurisdiction. Sometimes many of them, they work for the court system and they transcribe court proceedings, both civil and criminal proceedings. And so they provide a very fundamental service in our state. And I think legislators are in a unique position to understand some of the importance of that and how funny it is actually to see the technology transcribe what we're saying in real time and how inaccurate that is. Sometimes can be quite humorous for these
Senator,
purposes.
Can't you use one of the other mics? That one's been giving us a lot of feedback today.
How's this? That's better. Yeah, thank you. Yeah, so you can see how inaccurate the technology is regarding transcribing our audio recordings when we look at the YouTube feed that provides that closed captioning. And so and this is kind of a not as of an important setting as it is in a courtroom. And so the accuracy of having people's testimony being correctly and accurately transcribed is fundamental. And so they serve a very fundamental role in our judicial system. And they have come before the legislature today to ask for the district court to have the ability to set the fee that they charge per page for their transcripts. Kind of a goofy bill, and kind of a goofy bill, I think that this is set in statute. Currently, the fee is $3.25. So we're not talking about a whole lot of money or a whole lot of power here associated with that page per fee for transcripts. And that is set in statute as indicated. Let me just get to that page here. And that is the one piece associated with the court reporters' duties and operations that really is set in statute is this transcript fee. They would like the ability to raise that. It came to the legislature, would you raise our transcript fee? Recognizing the ability of that to pass either now or ever, and being so difficult to do, even when we're talking about a fee of $3.25, may not be worth or value the legislative time and a difficult ask for court reporters who actually need an increase in that fee, and really to allow that to go back through the rulemaking process to the district courts that are responsible really for their oversight and operations of their business. So I brought court rules to demonstrate how much of the judicial branch's operations are governed by rules and rulemaking. This is it. And the rules for district court reporters is also found in here, and I'll have a handout or provide it to you during this testimony, identifying all of those different tasks and duties and obligations of the court reporters that are actually governed by rule, kind of making this decision for you consistent with other obligations of the court reporters being subject to court rule. Also, I think it makes a whole lot of sense from a public perspective of recognizing who are the stakeholders involved with transcript fees, which are primarily attorneys who are responsible for paying those fees on behalf of their clients. Certainly, that argument could be made that ultimately the clients pay for the costs of those transcripts, but really the attorneys are paying, and sometimes they're fronting those costs and are responsible for ordering those transcripts and ensuring payment to the court reporter for those fees. And so a district court rule really does provide notification to all the lawyers in a much more significant way than the publication of legislation. Actually, there's far more lawyers paying attention to changes to the district court rules as opposed to what we're doing here in the legislature. Whether that's a good thing or a bad thing, I think that that's more true. That's the bill, Mr. Chairman, is it just allows the district courts to set those fees. I have a number of court reporters here and a member of the judicial branch, Judge Sharp, here with me today to testify about how this bill is important to them and how they operate. So happy to stand for questions. If not, I defer to them.
Questions for Senator Nethercott?
A couple of things I'd like to just add on as well, kind of a unique thing about that transcript fee. It does go to the reporter themselves in that professional occupation. They do have salaries, but they are allowed to collect that fee. The reason why that's important kind of uniquely is that they are responsible for providing their own equipment. And so that includes all the technology that they need, and they need to have backups as required by rules, so redundancies to ensure that if their machine breaks down, they have backup, and all other kind of trainings and continuing education that they're required to have. And that equipment, they front those costs themselves individually. The court doesn't pay for that or provide those services. So I think a very important factor for you to consider.
Questions for Senator Nethercott? Representative Oakley.
Thank you, Vice Chairwoman. And along those lines, has there ever been discussion, or what are your thoughts about, I mean, certainly the equipment could be provided by the courts, and then transferring that sort of system that we have, so that it is, the equipment's owned by the district court as far as continuing education that could be provided, and then just a straight salary, and then something that is interesting to me, and then the transcript being more owned by the court rather than an individual. So just what are your thoughts on that?
Senator?
Madam Vice Chair, yeah, great question from the representative. I think that issue, which seems simple on its face, highlights a challenge with our court system in total, and treading on touchy waters, as I have historically done as the former chairman of Senate Judiciary Committee. And that has to do with how our courts operate in this state. And each district court judge or each district court in the state is its own state agency. And they are responsible for submitting their own budgets to JAC. They are responsible for maintaining all of that kind of equipment, if it would be within that, or is that a courthouse operation, which would then be paid for by the county commissioners. And you get into kind of some where the buck stops situation, or who's actually responsible. And I don't know that it's something that the district court judges actually want to be responsible for individually, recognizing how, I would say, diluted their time is already from being in the courtroom, presiding over active hearings, and then the time it takes to render a judicial decision, and write and draft that work associated with the questions before the court, to then also have them be responsible for technology in the courtroom. The practice currently is the Supreme Court does that on their behalf. Lawfully, the Supreme Court actually doesn't have lawful authority to do that. It just happens because the district court judges kind of consent to that, for that to occur. And it's easier, for the Supreme Court that is required to present a budget to JAC to just take over that role for the district court judges. Otherwise, we have all the district court judges across the state trying to figure out how to present a budget to JAC and asking for resources. And one maybe decides to have one type of court reporting equipment, and one has another who maintains that. So it gets to be unwieldy. And I think in our court system and how we operate here in Wyoming, by having that structure, doesn't lend itself to that result. And having the court reporters who are actually responsible for the work product that they create, and under the kind of duty obligations of the court, so far that seems to be working fairly effectively without an overhaul maybe of our system, which may or may not happen.
Senator, you mentioned $3.25, and that seems like a very small amount, but when we're talking about hundreds of pages of transcripts, it does add up. So how long, or what's a typical week-long trial going to generate in terms of transcripts?
Mr. Chairman, I certainly could speculate as to that based on my own experiences, but you do have court reporters in the room. And I would also say, as a lawyer, though, I can tell you that that's also reflective of time and effort and skill, right? So the more it costs, the more time it took to produce and to do it accurately. I would say most of the court reporters' transcripts, though, reflect, from a 15-minute hearing to an hour hearing. And they actually are probably not transcribing long trials, just because the courts aren't doing that as often as they are smaller hearings, but certainly they're transcribing those long trials as well.
Representative Provenza?
Thank you, Mr. Chairman. Senator Nethercott, maybe this question will be better for our reporters, but I've had a constituent who's just been concerned about wanting to do an appeal and unable to. So attorneys, when approaching them, have said, get me the transcript and then we can talk about whether I would be willing to do that or not for you. And upwards of over $1,000, right? And so do you know if there's a process for folks who can't afford that, but need to be able to do that, to use the full process of our legal system.
Senator?
Mr. Chair, excuse me, Mr. Chairman. In a criminal proceeding, there certainly is. There's indigent fees and waiver of those transcript costs, whether they're retained by private counsel or the public defender's office. So in a criminal proceeding, the answer is yes. I'm not aware of that ability in a civil case unless it's through some type of legal aid program that the state of Wyoming provides by the lawyers in the state who also donate to those funds to allow for kind of free or discounted legal services to people who qualify.
Well, let's hear from the reporters in the room. Good morning. Welcome to House Judiciary. Please state your name and tell us what you want us to know.
I'm Tammy Fleming. I'm an official court reporter here in Cheyenne. I've been in that position for 25 years. Just got my pin. I have worked under 5 different judges while I've been there, and I'm here today representing the Wyoming Court Reporters Association. I have with me another reporter. We had a lineup, but the weather kept them there. This is Jan Davis. She's a federal court reporter, the District of Wyoming. She's been reporting longer than I have. Jan has been our past president of our Wyoming Court Reporting Association, and she has been, more impressively, president of the United States Court Reporter Association. So she is fully aware of what we do. She also is my companion in recruiting. And as the association, we have a committee set up just to recruit court reporters. Jan and I have done that 15 years now. So we know what it takes to get a reporter to come to Wyoming. I think Senator Nevicott explained what we do as court reporters, basically. We are judicial employees. We are unique in that we do bring our own equipment. And I'd love to answer that question. We update our equipment regularly. So for me, I have 3 computers, one at home, one in the courtroom, one in my office. I probably update those every 2 years, cycle them through. I have maintenance costs for my software, $1,000 probably a year. We all use different software. Whatever we use that we were taught to work with is what works best for us. And that's makes sense. We design our own programs for us as we're doing it. We buy that ourselves. Our writers, we change out about every 3 years. That's our most important tool. We have to maintain that every year for about $900. We change those out every 3 to 4 years at a cost of about $6,000, just under. And we usually keep our old one because we need a backup. We have backup costs for all of our stuff. Everything that we are writing in the courtroom, all the proceedings, we are required to keep for 10 years. And we do so. We have backup systems that cost us money. The state also does provide a OneDrive for us that we can back everything up. And that's very helpful. But the other things that we do are at our own cost. There are states that have moved to having the reporters do it themselves, are not getting paid for the 325. And they have purchased all the equipment, the software. Florida is one such state. One of our friends here, a court reporter, moved there. Hard transition, and the problems that they encountered are such as she had to learn a new program because they could only buy one program, and they did not change out the writers for 10 to 12 years. So you have an old archaic machine and maybe has a recording device that's a disc rather than what we do now that isn't real-time capable. And that's what they had to use. If they had problems, it really wasn't something the state had the budget to fix. We have our own equipment that works best for us to get our job done. And so that's what we want to do, is to have our own equipment. I have far different than what Jan and I have similar, but there are reporters across the state. We have 26 officials. And I would say we all have our own variety of what works best for us, the way that we were trained in our schools. If we were to do that, we would probably experience the same kind of things that they're seeing in Florida. And what they're seeing there is delays in transcripts, delays in appeals, sometimes months delays, because reporters are in the courtroom. They've decided we have a reporter. We're going to pool them and put them where we can, keeping them working all day writing. They don't have a lot of time to transcribe now. They also have no incentive. If you're not making any money on the things that you're doing, they don't really want to work till midnight to get things done for the next day. An expedited transcript is just not, it's not a possibility there, because a reporter is going to tell you, I'm going to go home and go to bed tonight. I'm not going to stay up for nothing tonight. Their salaries are a little bit more in Florida and some of the other states that have gone to this. But in reality, I think for the judicial system, for the public, for consumers, for parties, it's been a very big disjustice for them to not get the product that we can provide. And what we can provide is real-time transcript. And I've been watching today and seeing some of the mistakes. What I believe court reporters are the gold star of the record. We write, it comes up on a screen. Instantaneously, our judges are looking. A question pops up from a counsel or an objection. My judge, Judge Sharp, can look and go back, read the question, rule instantaneously. It's right there. We are accurate. We are required to be certified. 98% accuracy is what we need to pass at 240 words a minute. So you don't have people in the room that are sloppy. We also have proofreaders. We call them our staff. I have a proofreading staff I send everything to. I also have a scopist or 3 that on days when I am in court all day long and I have a long trial, and maybe Senator Nethercott needs something from that day, I can send it to my scopist and she can work on that, edit it and clean that up for me, make sure that it's perfect, look up the sites, get the spellings correctly. And you could have that by 6 o'clock that day and go home and get ready for the next day for your cross-examination. I believe what we do is extremely helpful to the community. It provides public access. And the best thing I think is that we as court reporters provide a transparency to the public of what our judges are doing and what's going on in the courtroom. It's instantaneous. It's right there. We also have a cloud service that can provide what we're writing to people in other parts of the country. So for instance, if I'm filling in for Judge Snyder in Rollins, as I was a couple weeks ago, I was doing it by Zoom because her reporter was sick. I was able to write to the cloud. It can go to her. She can see what I'm writing while she is holding her court proceeding. She can make her rulings. She could take her laptop back and make her decision quickly. So those are the kind of things that we can provide. Let me just check my notes very quickly, if it's okay, Mr. Chairman. I'd like to explain that this is really the first step for us. Getting here has been an arduous process for us. Thank you for listening to us. We're lucky that we have 2 co-sponsors here who have listened to us, ask questions. Representative Nemec and Representative Crago, you've taken the calls and you've listened to why we have a problem. And the problem being recruiting and retention. I testified before the Senate Judiciary in January, and afterwards somebody said to me, why are you so passionate about this? Why does it matter? Why are you here? And I could explain that I believe it's so important that we keep live court reporters in our court system. Anytime that I've seen digital recordings, anything else, there are problems. You don't get an inaudible from a court reporter transcript. We're going to stop people. We're going to slow them down. We're going to get clarity of any spellings, any cases that are cited, so that when the appellate court hears it, looks at it, they right then and there will have everything they need in an accurate format, which I think every litigant deserves in our state. I think they deserve the best product to go before the Supreme Court. What we would ask next for would be a 60-cent page rate increase. Now, I can tell you that in 2001, I was part of the process that came before the legislators and asked at that time for a page rate increase. We asked for $1 at that time. So that was a big ask, and we got that. It's been 21 years since we've come before anyone to ask for this. And it really actually got instigated when Jan and I were trying to recruit and having difficulty looking at surrounding states and seeing what they were paying, made us know that we're not in the game anymore. We're out. So when we call people and try to get them here, we just had 2 people come, one from Indiana, one from Texas. Their big question was, what are you doing about your page rate? Why is it still at a decades old rate that we don't want? I mean, many states right now, I would say the majority are at $5 or $6 a page. We are very low. I can give you the surrounding states, and we use surrounding states because we can't compete with California, Texas, New York, East Coast. You just look at what we have in our region, basically. So Wyoming is at 325. South Dakota has moved to 425. Colorado now at 4. Utah 450. Nebraska 375. And the federal courts, I believe, are at 365, but their salaries are also 20 to 30,000 more than ours. So those are the page rates that we are competing with as we are going out trying to call people and getting them to come to our state. We've sold them in the past by saying our lifestyle is here. We have safety. Your doors can be unlocked at night. We've been able to pull in the last 2 years people from Los Angeles, Philadelphia. We have Texas, Utah, Indiana soon, we hope, maybe. But right now we have 3 openings in our courts. That concerns us, and it should concern everyone. No court reporter means no record. We are pooling when we can to fill in, but we're simply busy. We can't do it for everyone. So point being that the openings right now that we have, one has been open since last April in Sweetwater County. We have worked so hard to fill that position. Judge Robinson has stepped in. She has helped us, and we sent out 450 emails personalized to court reporters. We got 1 response when they found out what our page rate was. Not interested. We got a lot of responses, or she did, I should say, because she sent it directly, asking why we had 80s rates nowadays, and were we serious? So it is a problem. I do know that a lady that I'm working with in Texas is extremely interested in Wyoming lifestyle for her children. She just knows that this could be great to be outdoors. She calls me regularly asking me, is that page rate increased yet? Because I could live on the salary if I just cut back. But if I have a page rate increase, it's really going to help me. So those are the key points I would really like to hit. As far as delays and all that, we have
Just a
60
quick
days.
question for you.
Excuse me, Mr. Chair.
What is the training like for court reporters? Where does one go to be trained to be a court reporter? How long is that training, and how many people are graduating every year from court reporter school?
I love that question because trends is what I talk about most, and I've missed it. When I started, and of course I'm an old reporter ready to retire in a couple of years, there were schools, brick and mortar schools all over the country. I went to one in Denver. You could do night school, day school, whatever you want. It was an average of about 2 years. As time went on, the court reporter schools have closed. I don't know of a brick and mortar school now. What we have gone to are online programs, which certainly work, but they are very, very difficult. I have mentored a woman in Casper, a young woman, and it took her 3 years, 2 babies in between and working. It's a difficult thing to do at home in your kitchen or living room when you're practicing on your own, trying to get through it. We used to have test examinations. We have certification tests that all of us, of course, must pass. It's called a registered professional reporter. That's the basic. That is at 225 words a minute. You must get that at 98% accuracy. Jan is a certified real-time reporter, which is very difficult. And we only have 3 of those in our 26 member group of officials. But those have to be passed. So even if you complete your online program, get your equipment, spend your $8,000 or whatever to get ready to go, you still have to pass the exam. So that requires generally taking on an online program that can be as expensive as $400 maybe, so that you can sit at home and practice. Then you set for the exams, and they're only every quarter that you can set for those exams. They're a national exam provided by our National Court Reporting Association, or USCRA, which is United States Court Reporter Association, also has one as well. Those are hard to sit for. They cost money. I believe it's 200 and something each quarter to set. You get 1 chance. 5-minute test, 1 chance pass or fail. So failing is pretty common until you can pass. All states have different requirements, of course, for court reporters based on what they feel that the need is. Some states have what they call a CSR, which is Certified Shorthand Reporter. And they're all supposedly set so that they meet the national standard. I know in Wyoming, that is what we do. We have a national standard of the RPR. So getting people that are certified is important too, so that
Thank
we can
you.
put it.
Very informative. Questions? Other questions from the committee? Anyone else wishing to testify? Oh, Senator Oakley.
Thank you, Mr. Chairman. So we heard a lot about the importance, of court reporters, and I certainly agree. But I want to focus on the point of the bill and what we're looking at doing, and if this is the correct solution for it. So we're hearing that we need an increase. So, I mean, one solution, of course, would be just to do that, to do the increase rather than a transfer of putting the rules in the district court. So I would like to more focus on why the need for that change. And then I'll just go ahead and continue. So we're hearing that the money isn't there. I'm interested in what like the yearly take home is for court reporters in Wyoming. I don't know if you want to share yours and what the average is to see where we're at.
Chairman, Representative Oakley. Yes, I'd love that. Our salary, it's set by statute. It is $64,275. That's all reporters making the same. I do acquire longevity pay, being there so long, 25 years. So I get a little bit more than my mentee that is now just newly hired. It varies, and we actually did conduct a study in the fall of 2021. We used the Supreme Court to help us with the actual figures. And basically what they are giving is our criminal transcripts, because that comes out of the budget there. That would not be paid for by litigants or counsel. And what we found is if we ask for a 60-cent page rate increase, that would represent only $69,000 total that would impact the budget. So we're not asking for a big amount, actually.
Representative Oakley.
Thank you. So the base salary is 64,000, and then how much is brought in via the fees? I would like the average for what the W-2s are for court reporters. Like how much is a court reporter
And
making?
we actually have that. Let me pull that up for you.
Yeah, if you can just tell me.
Many of us, excuse me, Mr. Chair, many of us have actually experienced losses in the last several years with COVID and everything. By the time we are paying for our equipment, our staff of Scopus and court reporter and readers, we've actually experienced a loss, and that's a common thing, which is you have your $64,000, you pay out your $5,000 in equipment. I paid $5,000 to my scopist. I just did her 1099. When I get done and I look at what I made and the overall, I had a loss last year. When we did this study with the Supreme Court, and let me find it, we had each person through a survey, called it a blind monkey, tell us what they made. We were surprised. People were making, I believe the average was $2,300. There was a person that had a huge trial and she made $18,000 that year. So we're not talking about a huge amount of money, unless of course, as you were asking about, a large, long trial and medical malpractice. It could be thousands. My expenses during that would also be high, because more than likely I'd be doing a daily transcript. I'd have someone sitting, editing as I was writing, paying them half of what I was charging so that I could get that out at the end of the day to those parties. So my costs are high to produce what I do produce. If I can find that, I'd love to give that to you. But I would say 2,300 would be about what we're looking at for an average, with some, of course, making more. Let's say you're in the Teton County area where you have a large amount of civil matters, which they do. That person would have higher incomes. So we reported that to the Supreme Court. We actually, each of us did that. I'm not finding it, but before I'm done, I'll make sure that I can hand that to you.
Mr. Chairman, if I might, while
Senator.
she provides that information, which I think she gave a ballpark of what the court reporters make. So this is not really a money-making enterprise for them, but does really allow for them to cover their out-of-pocket expenses that they're required to do. The why should this be in the district court? Great question. The reporters came to me and they came forward to a number of legislators to help with this issue. I actually wasn't the first they approached. And not surprisingly, there was little to no response. And we all know why that is. It's a fee bill increase. How many of you have voted for one of those this session? A handful have, right? And so the likelihood of that ever happening is not very high. And now you're talking about $3.25, right? So even though it would maybe be up to $4.25, which would still be below the average in the region or even higher, they're still not even going to get that. And then kind of the unique difference from my perspective of why is this even in the legislative wheelhouse, right? Do I really want to bring a bill for $1 increase for transcripts per page? The effort, the conversation that comes around from the legislative interaction. Do I feel confident that this could be in a district court rule and it still goes through public process with transparency, with reasonable rates? I absolutely do feel confident in that process and that fairness can be achieved and the court reporters aren't doing a money grab for another $1,000 a year. You know, I feel like that's a good result, recognizing that this is a fee increase that affects individuals. So unlike the court filing fee, that's a joint judiciary bill that we've seen to just provide parity amongst the filing fees from a probate to a civil fee, right? Just a simple request from the court clerks on that has experienced great difficulty, right? I'm not even sure the current status of that bill, if it's even alive. And so that goes to the courts, right? And that is not a personal ask. And there is a system in place to come to the legislature kind of on behalf of the clerks, but not really. Now you're talking about court reporters. She should be in court right now, right? She has a job to do. So she needs to get permission to be here, to come ask the legislature, of which there's very little interaction with, right? I mean, it's good that they know a local lawyer who's actually in the legislature to do this work on their behalf. But if that's not the case, this is a huge ask of individuals to take in order to pay for their out-of-pocket expenses to provide what is a public service. So that's why, to me, it makes sense to just shift it back into the district court until we figure out maybe a different way to do these services entirely, but that's not a solution before us right now. And so this one seems to make a whole lot of sense without you needing to vote on a fee increase.
Representative Provenza.
Thank you, Mr. Chairman. Thank you for being here and for your service. I mean, seriously, the transparency and the ability to get this is important, and I support that fully. I do want to ask, does this give more potential discretion to maybe the district courts or the reporters in terms of, I don't know if sliding scale or something would make sense here? I mean, talking about, I brought up the issue of potentially indigent clients, someone in civil litigation who can't necessarily afford those big transcripts, right? Would this maybe untie your hands in that way?
Thank you. What I can tell you is we have been working very carefully with the District Court Judges Conference to get to this point. So I may not be answering this correctly the way you want me to do, but we work with them and let them know what we've done wage surveys, state surveys, all of that, so that we know exactly what other states are paying, so we know what the trends are. No.
She wants to know how to offer free services to the poor.
All right. So what we do in criminal matters, we of course send them, they do inform a papyrus, and that's paid for by the county. And so that is not ever a problem that we can see. In civil matters, I know that each of us, just because it's something that we do, we provide pro bono services when we know And I won't say that all the time, and I won't say that with every reporter. If we're extremely busy, we have 8 appeals that are due within 60 days, and someone comes to me and needs a 2-week civil trial that they paid an attorney on, but can't pay me, I think I'm going to say no. However, if it's a divorce proceeding where they need a ruling, and I know it's crucial for them to get what they need, I always do those for them for free. I just did one yesterday. I believe they need it, and I know that my judge will say to me, it will help them, and it does help them. So yes, we do provide those services free if we feel it's needed. I always ask the attorney that asks me, if they're represented by an attorney, are you doing this for free or are you getting paid? It makes a difference to me. If they're doing it for free, so am I. If they're getting paid, I somehow feel I should as well.
Thank you. We're getting close to 9:30. Are there other witnesses, Senator, who want to testify this morning? Not necessarily. Okay.
Thank you, Chairman.
Thank you.
Good morning.
Good morning. Please identify yourself and
Mr.
tell us what
Chairman.
you
Yes,
need
my
to hear.
name, I'm sorry, my name is Steve Sharp. I'm a district court judge here in Cheyenne. There are 24 district court judges across the state. And I would just like to tell you how strongly we support this bill. This is a bill that's very important to our judiciary. We have a huge problem right now in our state, and that is recruiting and retaining qualified court reporters. And it's getting more and more challenging. As Tammy mentioned, there's 3 openings right now across the state where judges are trying to fill those spots. And it's getting harder to find court reporters to come into the state because of the low transcript rate. And this change in the bill, and thank you so much to Senator Nethercott for the time that she has put into this to sponsor it, would make the process so much simpler for us to not have to wait 21 years again before we come back for a much needed change. I wanted to comment on one thing that I know there was a concern expressed that if you pass this bill, that somehow or another you're abdicating your responsibility to oversee our spending and our budget. I would tell you that's not the case at all. Every 2 years, we have to appear in front of the Joint Appropriations Committee and justify our budgets. If I want to increase my budget, if I want a copy machine or something like that, I have to explain why I'm asking for more money this time. So we're accountable for the money we spend, and you will always be accountable for the expenditure of state funds. The last thing I wanted to say is that judges share your commitment to keeping our court costs low. We never want to price anybody out of the court system. It's important to us. We have an ethical responsibility to make sure that our court system is accessible and affordable for everybody so that they can afford it. And I'm proud of the fact that Wyoming, we have some of the lowest court costs, filing fees in the whole Rocky Mountain region, and we're very proud of that. To address your concern, Representative Provenza, about indigent and how this might impact folks that don't have any money. Those transcripts are largely paid for through the state. So a criminal transcript would, if a case goes up on appeal, that would be paid for by the state. So it would impact what the state would have to spend for that transcript. Same thing for like a termination of parental rights. Those transcripts are all paid for by government money. In closing, I would just say that this is a bill that's long overdue from our standpoint. If it passes, I would submit to you, it would have a pretty minimal fiscal impact. It would have a major impact on our ability to recruit court reporters. So I know you have other bills you need to hear, but if there are any questions, I'd be glad to try to answer them.
Thank you for being here, Your Honor. Any questions? Thank you again. Senator, you want to bring us home?
Mr. Chairman, thank you for your time this morning. As you can see how important this issue is to the court reporters, the amount of effort comes forward for what may be $1 or $1.50 page increase, and why that may not be appropriate for the legislature. And it's something that we can turn to our partners in the judicial branch to ensure that the system continues to run smoothly. I just also brought this. This is the Wyoming Court Reporters Manual that they have that I printed. I learned a lot of things about court reporters despite practicing in this area for so long. And as a point, so I hope you support them and recognize it's such an important profession to us and support this bill. as a point of kind of humor, I'm certainly always afraid and have a healthy fear of every judge in a courtroom, but nothing quite like a court reporter who will teach you how to speak slowly and clearly. And if you do not, you you will learn the hard way with a good slow it down in the courtroom. So the scariest person in the courtroom really is that court reporter.
Thank you. Eliza Butler, you want to bring her in, please?
Good morning, Mr. Chair, members of the committee. My name is Elisa Butler and the State Court Administrator for the Wyoming Judicial Branch. I really am here just to stand by and answer any questions that you may have. I know you've heard lots of testimony already this morning, but I'd be happy to answer any questions if there are any.
Any questions for Ms. Butler? Seeing none. Thank you for joining us. Anyone else? Pierre, anybody else? Anybody else in the room? Okay, I'll close public comment. Committee, what's your preference? Moved by Nemec, second by Crago. Any amendments? Discussion? Crago.
Thank you, Mr. Chairman. So I just want to echo some of the comments that the good senator already made, which is and that we heard testimony about also from the reporters is, and unless you've practiced, especially in the civil area, you don't understand what these reporters are doing on a daily basis. They sit in the courtroom with us all day, then they go home at night, which the rest of us aren't necessarily working. They're preparing the transcripts, they're getting ready to go out. I mean, if you look at the rules, for example, which they're governed by rules of appellate procedure, they have a timeline. They have to turn around those transcripts within a certain amount of time, which often requires work on the weekend, work at night. And I just appreciate everything they do. And we need to make sure we can continue to have good court reporters in our courtrooms going forward. It's essential. If you go to circuit court, there isn't one. And there's a marked difference in what the record looks like and how that's used going forward. The transparency isn't there. Yes, you can go listen to it, but it's not useful, really, to be honest. And so we need to make sure we have those folks in the courtroom doing what they're continuing to do. So I'm obviously on the bill. I'm a co-sponsor, but we need to vote aye. Thank you, Mr. Chairman.
Representative Chester.
Thank you. I'd like to echo what the good representative from Mid-State said. Having tried a number of cases when I was in practice, I know the value of a good court reporter. They're invaluable. The transcript is the most important document comes out of that, and they're essential. And I know that from I think of 2 cases in 20 years where I had a bad transcript. It happens. It's rare, but it happens. And those cases were destroyed because I couldn't file an appeal. The appeal was a bad transcript is a terrible thing. It is very, very rare, but we need to make sure that we have good reporters. And I am therefore 100% behind this bill.
Representative Craig.
One other thing, Mr. Chairman, I just wanted to point out that the lawyers will have a say in the fee. I mean, it's rulemaking. The district court conference will send that out. All of the members of the bar in Wyoming will have some say. They'll have the opportunity to make comments, and that's what will regulate how high it goes up or whether it goes up at all. I mean, it'll be, up to the bar, and they'll have a lot of say in that.
Okay. Anything further? I'll just conclude with saying the good senator will tell you that I was not an enthusiastic supporter of this legislation early on. But I think one thing really struck with me, and that was the legislative inaction for 21 years, right? And that speaks to, that's on us, right? And the truth is, we don't want to deal with these little fee increases. We don't want to deal with big fee increases. We just don't like to deal with fee increases, and the cost gets shifted to others. So I'll be an aye vote today. With that, I'll close public testimony. And Debbie, you want to call the roll?
Representative Crago,
Aye.
Representative Chestick,
Aye.
Representative Haroldson. Representative Jennings. Representative Nemec.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Rodriguez Williams.
Aye.
And Chairman Washit.
Aye.
We have
Representative
8
Craigle.
ayes and 1 no.
As I've talked over the top of you, and a court reporter would tell me not to do that. So Debbie, would you repeat the total?
We have a total of 8 ayes and 1 no.
Thank you. Representative Craigle, we carry this on the floor.
Yes, sir.
Thank you, Senator. That brings us now to Senate File 80. Welcome. I think this is your first time before House Judiciary.
It is. Thank you, Mr. Chairman and committee. I'm going to be fairly quick with this. It's a pretty simple, straightforward bill we've been working on for about 2 years. The impetus behind this bill or something that
Senator,
really-
state your name for the record.
Oh, I'm sorry. Senator Troy McEwen, Senate District 24, Campbell County. The impetus behind this bill, and what really drove it home for me was a little while back, we watched Roy Edwards pass away from COVID. During that process, he collapsed at his house, was taken to the hospital, and then they moved him to Casper. They did not let his wife go with him. In fact, they quarantined her to her house. So his children showed up and they didn't even get to go see him and basically ended up dying alone. And I'm sure everybody has stories similar to this, but it kind of brought up the need to look at what we're doing. We've worked this bill with the Hospital Association and CMS. They're actually in support of it. It took a while to get to where we were all in agreement of what it needed to look like. But at the end of the day, the premise behind the bill just sets up a requirement for healthcare facilities such as hospitals, nursing homes, things of that nature, extended care places, to look into ways to provide for visitation instead of just shutting it off. It allows them the freedom to determine the hours and the number of visitors. It allows them the freedom to determine any of the protective measures or clothing that needs to be worn. But it does require them to look into it and provide the service and provide the care for the people that they oversee. Really, that is the bill in a nutshell, and I'll stand for questions.
Representative Craigle.
Thank you, Mr. Chairman. So I have some technical questions, I guess, just about the wording. So on page 1, it says a healthcare facility that provides 24-hour per day care, and then it has a comment, says including. And if we go to Title 35, Chapter 2, and look at 901, Section 901, healthcare facilities already defined. And it includes a lot more things than just what you have listed here. And I'm wondering, why are we risking narrowing down what it actually applies to, which healthcare facilities it applies to by listing those rather than just using the definition in the statute?
Senator.
Mr. Chairman, I would agree with you. We probably should use the statute definitions instead of these.
Further questions? Representative Craigle, did you have additional?
Thank you, Mr. Chairman. Sorry about that. And so then on the second page, at the very top, it says the visitation required under this section shall not apply to essentially Title 25. And I understand that. I think that's good language. But then the next clause of that sentence says, or adults who have been convicted of a crime and are in the custody of the state or a local jurisdiction. I guess my question is that even needed? Because we're only talking about healthcare facilities? Or are we talking about people who are in a healthcare facility that are under guard? So if so, and then it needs to be in there, then do we need to use the word convicted or accused? Because we have, charged, because we have people who would be, for example, under arrest in a hospital, but not yet convicted.
Senator.
Mr. Chairman, that was some language was put in by the Hospital Association. I'm not sure. I do believe it should say charged also.
I believe Mr. Boley will be joining us by Zoom and we'll get his input on that. Representative, do you have further? Okay, other questions for the senator on the bill? See none. Do you have any other witnesses with you today?
I think just Mr. Boley was gonna.
Can you bring Mr. Boley in, Pierre? And Provenza.
Thank you, Mr. Chairman. On page 2, where we talk about shall provide a written copy of its visitation policy to every person admitted to the facility or to that person's representative. Was there any discussion in committee or from folks that you talked to about what that looks like on the ground in terms of, I mean, if you have like a hospital, you have maybe hundreds of people coming in, does that mean you physically have to hand everybody a policy?
Mr. Chairman, I think the intent is it has to be published, whether it be a handout that people get when they come in or a board, just so it's written out and understood. Thank you, Mr. Chairman.
Okay, Mr. Boley, welcome this morning. Tell us what you'd like us to hear.
Thank you, Mr. Chairman, committee members, Eric Boley with Wyoming Hospital Association. I join you from sunny San Antonio. It's 85 degrees here, not rubbing it in or anything.
We can cut him off at this point, please.
But I'm hoping to be back with you in person tomorrow. Senator McEwen's done a great job of explaining the bill. Obviously, the last few years have exposed some weaknesses in some areas of concern, and don't want to relitigate the pandemic, but visitation is super important to residents in nursing homes and to patients in the hospitals. We can support this bill. It basically just codifies our already existing visitation policies and puts it in statute. Your question about some of the verbiage about limiting visitation. When we worked on this last year, towards the end of the session, Senator McEwen and I talked about certain circumstances that might arise where we need to limit visitation. And I don't know if we've got the sweet spot there. I think Representative Crago may have some ideas on wordsmithing, but there are certain circumstances with some of our patients where we have to limit visitation. And so I think we just tried to address that in the verbiage. As far as Representative Provenza's question, I don't think it's going to be too onerous as far as posting our visitation guidelines. We post a lot of other things in our emergency rooms about payment and other things. So I think it's something we can do. And then obviously in nursing homes, upon admission, we can make the family as well as the residents know what our visitation policies are, and they may change. Who knows what the future will hold, but right now I don't see any problems with that. So we can support the bill in its form, and if you need to tweak the language, we'd be fine with that as well, as long as we don't change the full intent of the bill. With that, I'd answer any questions.
All right, Representative Oakley.
Thank you, Mr. Chairman. Thank you, Mr. Boley. I'm interested in this notice requirement and trying to maybe narrow it a little bit. Just so, anyway, so I'd like your opinion on providing a copy to every person in the facility. Is that going a little far, or what are your? I mean, I know you somewhat addressed it, but the second half, of course, posting it, you talked about, but what do you have to say? What do you think about shall provide a copy to every person? admitted.
Mr. Bowley.
Mr. Chairman, Representative Oakley, I think if we could simplify it, obviously and make it a little bit better. If I think we could put it on our websites and then maybe have a board as people come in. I do think that having a lot of paper copies, especially when you look at some of our larger facilities, it might make it a little bit cumbersome. And so if you know, Senator McEwen's okay with it, I think if we could just put it on the websites of the different the hospitals and maybe post it in a public area. And then I think we could go from there and make it a little bit simpler.
Thank you, Mr. Bowley. Any further questions, Mr. Bowley? All right. Thank you, Mr. Bowley.
Thank you.
Senator McEwen, you want to bring us home?
I do. Thank you, Mr. Chairman. I don't have a problem with any of the changes discussed. The intent is to make sure somebody can go look and see what the rules are, whether it's a piece of paper, a website, or a board. To me, it doesn't matter. And I don't think it changes the intent of the bill. And I don't think it changes the intent of how everything happens. The other thing I'd like to point out is what the bill does do is it's not just focused on times of pandemics or, you know, when the huge Ebola outbreak happens or anything, but day-to-day business also. As we watched in some of the elderly care facilities, they literally shut down all visitation for anybody. But they have this thing called healthcare employees who came and went every day. And somehow COVID didn't get the memo that it couldn't attach himself to the employees and the COVID still got in. It's kind of funny. I run a grocery store and we didn't put arrows down and say, you have to walk this way down this aisle and this way up the other aisle. Because once again, COVID could go both ways if it wanted to. It really didn't behave for us, did it? And with that, I would request an aye vote. Thank you, Mr. Chairman.
Thank you. Committee, your preference?
Bill.
Moved by Representative Harrelson, second by Representative Oakley. Any amendments? Representative Provenza.
Thank you, Mr. Chairman. On page 2, line 21, I would strike after policy to every person, and then the remainder of line 22 and insert after policy upon request. So instead, and if I get a second, I'll explain.
Is there a second by Representative Oakley?
Thank you, Mr. Chairman. So basically just wanting to make it so that there isn't any question of you don't have to hand somebody your policy every time they walk in the door. You just, if there's a request for it, it's to be known that it's a public document, and then it is also required that it shall visibly post in the facility a copy. So I'll read it again. So what it would say is, so on line 20, you start with a healthcare facility shall provide a written copy of its visitation policy, insert upon request, and then we're canceling out the remainder of the line. And then crossing out all of line 22. So then that sentence finishes with its visitation policy upon request and shall visibly post in the facility one copy of the most current visitation restrictions.
Debbie, you have that? Yes. Everybody clear on the amendment? Any discussion on the amendment? Question on the amendment? All in favor, say aye. Aye. Those opposed, no. That amendment has carried. Any further amendments? Representative Oakley.
Thank you, Mr. Chairman. I would like to move an amendment that says, page 2, line 4, or adults who have been charged, add charged with or before convicted of a crime. Charged with or convicted of a crime.
Line 4, we're inserting after the word been, charged with or.
I'll second that.
second by Representative Haroldson. Everybody clear on the amendment? Discussion on the amendment? Debbie, do you have the amendment? Question being called. All in favor of the amendment, say aye.
Aye.
Those opposed, no. The amendment carries. Further amendments, Representative Craigo.
Thank you, Mr. Chairman. This is the one I brought up a little bit ago, page 1, line 12. And so after I'll move the amendment and then I'll explain what I'm doing. Line 12, starting with the comma, delete the rest of the line, all of line 13, all of line 14, and line 15 through the word facility.
Second.
Moved by Representative Craigo, second by Representative Oakley. You want to describe your amendment?
Yes, sir. Thank you, Mr. Chairman. And so all of those items listed there, except one, and I'll get to that in a second, are already defined as part of a healthcare facility. If you look at the definition of healthcare facility, all of those entities are already listed. And so we're just doubling up, but then we're also excluding a whole host of other ones that are not listed here, but are considered a healthcare facility under section 901. The only one that's not is psychiatric care facility. So now we've also created a inconsistency within the language because a psychiatric care facility is not a healthcare facility under the statute. And so I think on top of the other ones already being there, the one is not. And so we're creating an inconsistency within the statute. So that's the purpose of my amendment, is just to make it clear we're talking about healthcare facilities, period.
Question.
Just a clarification on line 15, the last strike is the first facility, and then it will include or assisted living facility.
Sorry, second facility, Mr. Chairman. So the only words left will be shall allow visitation. So it'll read a healthcare facility that provides 24-hour per day care shall allow visitation.
Debbie, do you have that? Representative Chestick.
Essentially friendly amendment, just to clarify, do you want to insert somewhere as defined in 35-2901? Just to make sure that it's clear that to help any reader who's not familiar with defined terms.
Representative Craigo, response?
It's surely friendly, Mr. Chairman. It doesn't bother me. I guess the question would be just for LSO, whether that's part of our drafting policy or not, whether it's actually necessary, because we're already in that title, that chapter, and that article, which is the 900s.
Representative Oakley.
Thank you, Mr. Chairman. And for that last reason that the good representatives said, it's defined in this section, so I don't think it's necessary. Yeah, redundant.
Okay, anything further, committee? So we have the amendment, Craigo amendment on page 1. Any further discussion? Question being called. All in favor, say aye.
Aye.
Those opposed, no. That amendment has also carried. Any further amendments? Question on the bill. Debbie, please call the roll.
Representative Craigo,
Aye.
Representative Chestick,
Aye.
Representative Haroldson,
Aye.
Representative Jennings, Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Aye.
Chairman Washut,
Aye.
total of 9 ayes and 0 noes.
Representative Jennings, being a friend of Roy Edwards, would only carry this bill on the floor. Are you on there? You're not on there. I didn't think you were on there. Representative Haroldson? All right. The other deputy sheriff.
There you go.
There we go.
I'll take another up.
Very good. We're done for the day. I think we have 2 bills left for Friday.